Assalamualaikum warahmatullahi wabarakatuh. So my name is Muhammad Atiq bin Muhammad Tajuddin. So I will start this presentation. So for the presentation, I will start with the introduction. So introduction is the Malaysian legal structure consists of the legislative and the judiciary arm of the government. So however, this arm operates as the independent institution. So the judiciary will be the discussed as its primary function is highly relevant to the current and also the prospective tertiary student in Malaysia. Next is the Malaysian court system and alternative dispute resolution, or we can call it ADR. So there are two. First is the Malaysian judiciary, and second is the judiciary structure. So for the first one is the Malaysian judiciary is the government agency that ensures that the Malaysian federal constitution and constitution is upheld at the all time and comply with all the cases. So it refers to the dispute between the individual and the state, between the state and between the federal government and the state. So the judiciary operates by means of the various courts with different level and authority. Next is the judiciary structure. It is about the court into the two parts, the superior court and also the subordinate court. The alternative dispute resolution, or we can call it ADR, refer to any means of the setting dispute outside of the courtroom. So ADR typically include yearly neutral evaluation, negotiation, conciliation, mediation, and arbitration. So for the mediation, it's also the informal alternative to the litigation. So next is the function of the authorities of the various court. We have two. We have the superior court and also we have subordinate court. So for the superior court, if the high court decide on the appeal case from the subordinate court, is authorized to the settle or dispute of a criminal or civil nature. So cases resulting in the death penalty are handled by the High Court. The Federal Court has jurisdiction to decide on the dispute between the state or between the federal government and the state. So next is subordinate court. The court in the Malaysia have the power to decide on civil and criminal cases. The magistrate court has jurisdiction to try civil cases whose claim does not exceed 35,000. So the children court is designed for the cases involving child less than 18 years of age. The criminal cases must have a maximum penalty of 10 years in prison with a fine only. So that's for me. Thank you.
I will explain to the next slides. That is arbitration. Arbitration involves the determination of disagreement between parties outside the court system. Arbitration is a faster and cheaper process than the formal court process, and encouraged especially where the parties are not interested in potentially lengthy court proceedings. Okay, next is a BBA contract. A BBA contract is the most common form of transaction used in Islamic banking in Malaysia. It is a deferred payment sale contract used to finance the purchase of properties by the bank's customers. The bank will purchase the property from the customers pursuant to a property purchase agreement for a purchase price. The bank will sell the same property back to the customer pursuant to a property sale agreement for a sale price. The purchase price is called the facility amount or the financing amount, and the bank will pay the same immediately to the vendor. The sale price will be paid by the customer to the bank over a period of years by monthly installments. The BBA contract is therefore complete with the property purchase agreement and the property sale agreement. There is no need for a novation agreement. The bank may take a charge on the property as a security arrangement. Okay, we move to the next slide. That is Court of Appeal. The appeal before the Court of Appeal involved 9 cases. Bank Islam was the appellant in all the cases. The Court of Appeal accepted the High Court's finding that riba or interest is prohibited in Islam. However, they disagree with the land judge method of comparing a BBA contract with a conventional loan agreement, as the two instruments of financing are not alike and have different characteristics. A conventional loan agreement is a money lending transaction, whereas a BBA contract is a sale agreement. The High Court judge had ear when he equate the profit earned as similar to riba or interest, when the BBA contract is in fact a trade transaction which has a purchase agreement and sale agreement. Okay, that's all from me, and I will pass to the next presenter.
Assalamualaikum warahmatullahi wabarakatuh. My name is Islamic Abu Bakar, and I will present about the jurisdiction of the Sharia Court. Okay, first are the governing law clauses. A commercial contract is a legal relationship. Different countries has different law, and the effect of those law also can be different. This is particularly important issues in an international context, where a contract may be connected with several places. In such cases, there are several legal systems with potential relevance to the contract, making it all the more necessary to decide especially what system of law will govern. Okay, next are the important factors to know about the governing law clauses. The first factor is the choice of governing law is not based on my law or your law. Some international contracts are governed by law have nothing to do to the other parties. The second factor is a common mistake is referred to a country which has more than one legal system. Sometimes the ambiguity can be resolved by considering the wider context. The third factor is we should avoid splitting the governing law. Such wording is a recipe for parallel litigation and associated cost and delay. The last but not least factor, for similar reason, one should generally avoid clever formula. It can be appropriate to include such as formula, but this is a highly technical issue on which professional advice should be obtained. Okay, next are the jurisdiction clauses. It is inevitable that contract will produce dispute from time to time. Sometimes parties choose to resolve dispute by arbitration, in which cases they include arbitration clauses in their contracts. On other occasions, parties are happy to rely on the courts in order to handle any of the dispute. An example of jurisdiction clauses, the parties submit all the dispute arising out of or in connection with his agreement to the exclusive jurisdiction of the courts. Okay, next are the factors to be considered in drafting clauses. Okay, the first factor is jurisdiction clauses represent the party's decision to resolve the dispute in court. It is therefore an alternative to arbitration. If in doubt, you should choose a jurisdiction clause or an arbitration clause, but you must not choose both of it. The second factor is if you want to provide for particular cause, only the clauses should clearly state that the jurisdiction is exclusively. Conversely, if you want to include a non-exclusive jurisdiction clause, you should spell out exactly what your intention is. The third factor is, as with the governing law clauses, simple is the best. Trying to assign different types of dispute to different jurisdictions frequently give rise to problem. Although there can be workable solution in some particular cases. The last but not least factor, consider carefully what the clauses will be effective in legal and commercial terms. Will a court take jurisdiction just because the party have chosen it in their contract? Will a judgment from the court be enforceable in the place where the defendant assets are located? Some of the questions that need to be considered. Depending upon the answer to this question, incorporation of arbitration clauses may be better option on some occasions. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Saiful Izzuddin bin Saiful Bahari. Okay, for the next part is I'm going to explain about selected cases of Islamic banking and finance dispute. Okay, the example given as in the book are Shamil Bank of Bahrain versus Besimco Pharmaceutical Limited, and others during 2004. This and appear from judgment of Mr. Justice Morrison, whereby he gave summary judgment in favor of claimant Shamil Bank of Bahrain against the first and the second defendants as principals debtors in respect of monies advanced loan to them by bank under various financing agreements, and against the third, fourth, and fifth defendant as guarantor of certain of those agreements. Okay, next is clause 35 and 36 of the article provided. The Religious Supervisory Board shall ascertain that the company investment and activities conform with the principle and provision of Islamic Sharia. It shall, in particular, discuss with the members of the board of directors, managers of the company, of any subsidiary or affiliated company under its control, such conformity and the business carried out by them, and shall request any information it deems necessary. In particular, the Religious Supervisory Board shall adopt all the crucial decisions for applying of the Islamic Sharia to ensure the realization of the object for which company was incorporated. Okay, next is the issue on these appeals. The number of defense were advanced by the defendants before the judge below, certain of which were regarded by the judge as having the hallmark of Trump defenses designed to avoid delay payments. However, the principal defense advanced was that A. On the true construction of governing law clause, quote in paragraph 1 of this judgment, the Murabahah agreement and the ESUA were only enforceable insofar as they were valid and enforceable both. Okay. One, in accordance with the principle of the Sharia, and number two, in accordance with English law. Okay, next is the another cases that can be highlights is Bank Kerjasama Rakyat Malaysia versus MC Corporation Sendirian Berhad. In these cases, the appellant had granted the respondent a loan facility of RM20 million under Islamic banking principle of Al-Bay Vitamin Ajils. The respondent default in the loan repayments and the appellant issue a form notice under National Land Codes. The respondent failed to comply with the notice and the appellant sought for an order for sale of the security charged under the loan facility. For conclusions of the case study, this case highlighted some of the problems that will occur if the legal and regulatory framework is not clear. Failure to have such mechanism will open a floodgate of cases on Islamic finance, as defaulting parties will be tempted to raise the issue of Sharia compliance as escape liabilities. That's all from me. Thank you.
Thank you to previous presenter. I will continue. My name is Siti Fajarina Putri binti Sabrai. My metric number is 2019814894. Arab Malaysia Finance Berhad versus Taman Ihsan Jaya Sendirian Berhad 2008 5 MLJ 631. The issue: amount customers should pay under Al-Ba'i Bitamin Ajil facility in the event of the customer default has long plagued the banking industry, but was assumed to have been settled with the decisions of Abdul Wahab Patel J in Afin Bank Berhad versus Zulkifli bin Abdullah Afin case, which was followed in at least two or other high court cases, namely Malayan Banking Berhad versus Marilyn Siok Ling, the Marilyn case, and Malayan Banking Berhad vs Yaqub bin OJ and Honor for the Yaqub case. The decision in Arab Malaysia Finance has serious ramifications for the banking industry. It appeared to suggest that a bank providing Islamic facility under the Al-Bai Bituman principle must purchase the property to be financed directly from the vendor of the property, must step into the shoes of its customer as the purchase and adopt all the later obligation under the sale and purchase agreement with the vendor. In order for the bank to become genuine seller of the property under the Al-Bai Bituman transaction, the decision is in Malaya Malaysia Finance is pending appeal. Next is Investment Dark Company KSSC versus Bloom Development Banks SNL 2009. This is an appeal from the order of Master BG made on 23 July 2009, whereby he granted summary judgment to the claimants, which I should refer to as Bloom, as part of its claim in the amount of 10,733,292.55 US dollar. The appeal is brought with the permission of Mam J. The claim arose out of various deposits, for want of a better word, made by Bloom, with the defendant referred to throughout the hearing as TID. I should so refer to it also. The master found that there was an agreeable defense to the contractual claim in alternative basis that he should have got judgment on the contract claim. The judgment that the master granted was the repayment of all the principal sum advance or deposit, and not for my profit element or as TID would have it interest. However, TID is incorporated in Kuwait. Under its memorandum of association, its object clause is qualified by Article 5, the clause of the memorandum being referred to as article. There is a dispute as to the translation of the memorandum, but that is not a dispute that can be resolved on a summary judgment application. The translation I have seen translate the relevant word as provided objective Article 5 of the memorandum provided. The objective for which the company is established shall be Sharia compliant. None of the objectives shall be construed and interpreted as permitting the company to practice directly or indirectly any usury or non-Sharia compliant activity. Thus, it clearly intended to be a broad with as the refers to indirectly as well as directly demonstrate a series of objectives, or as an English lawyer would say, object, follow in Article 6. They have been amended from time to time, most significantly objective to state as follow. Carry out all financial transactions in a Sharia compliant manner. However, in all cases, these items should not be construed or interpreted as permitting the company to practice any activities related to banking profession, except cash deposit, saving deposit, account opening, issue of letter of guarantee, open documentary credit, and other banking activities. Have seen in a number of examples the activity of TID and its subsidiaries are said to be carried out in accordance with noble Islamic Sharia principle and are said to be the selling and leasing of motor vehicle and real estate property to consumer based on, among others, short of contract wakalah. Contract wakalah appear to mean agency. Formally, therefore, the appeal is allowed by conditional upon the interim payment in the amount of the present judgment being made to Bloom within a period upon which I will now hear agreement. I should add that my jurisdiction to attach a condition has not been challenged and is confirmed by the other case was Muhammad alias Ibrahim versus RHB Bank and Anor 2011. The plaintiff entered into a sale and purchase agreement to purchase properties situated within the Kota Warisan project, the land, and a building agreement to construct and complete a detention house on the land on 29 January 2004, the first defendant granted the plaintiff a BA bituman facility and cash line facility. the facility agreement to finance the SAE construction project on 8 March 2005, all asset rights and liability of the first defendant in respect of Islamic banking business were vested in the second defendant. On 18 May 2010, the first defendant application under 018 R19 of the Rule of the High Court 1980 to strike out the plaintiff claim was dismissed. However, during the striking out application, it was realized that there were some issues which merited a reference to the Sharia Council SAC pursuant to SS 56 and 57 of the Central Bank of Malaysia Act 2009. The Act will come into force on 25 November 2009. In response, the amicus curiae submitted that the impugned provision was enacted pursuant to Item 4K of List 1 in the Federal List of the Ninth Schedule to the Constitution, which was the certain Islamic law and other personal law for the purpose of federal law, and that since the judicial power of the court was derived from federal law, to the court was bound to rule that the impugned provisions were valid. However, the amicus curiae took the stand that this court had the jurisdiction to determine the question posed by relying on two positions of the relevant law, namely Art 121 of the Constitution, which determined the issue of judicial power, and Item 4K of List 1 in the Federal List of the Ninth Schedule to the Constitution, under which the impugned provisions were passed. Missing the plaintiff application with no other as to cause, the impugned provisions were valid federal laws enacted by Parliament. As such, it was within the jurisdiction and power of this court, as well as the non-mandatory remedy of S84 of the CGA, whether to refer or not refer this matter to the federal court. In this case, the court requests all parties to proceed with the court of the matter. Second, in Malaysia, Islamic law falls under the jurisdiction of the Sharia courts, which derives its power under a state law enacted pursuant to Art 74(2) of the Federal Constitution. But in case involving banking transaction based on Islamic principle, it was the civil court that had the jurisdiction to hear this matter. However, with the development of Islamic financial instrument, it became important to establish one supervisory authority to regulate the uninformed interpretation of Islamic law within the sphere of Islamic finance and banking. And in Malaysia, that the SAC was established as an authority for the ascertainment of Islamic law for the purpose of Islamic banking business, takaful business, and Islamic financial business. Thus, if the court referred any question under S56 1B of the Act to the SAC, the latter was required to merely make an ascertainment and not a determination of the Islamic law related to the question. The sole purpose of establishing the SAC was to create a specialized committee in the field of Islamic banking to ascertain speedily the Islamic law on a financial matter. As such, there was no reason for the court to reject the function of the SAC in ascertaining which Islamic law was to be applied by the civil court in deciding a matter. Thirdly, the root word ascertain that was used in S51 of the Act was also similar to the word in Item 4K of the List 1 in the Federal List of the Ninth Schedule to the Federal Constitution. For the ascertainment of Islamic law and other personal law for purpose of federal law, the court found that such similarity and the word determination which appear in List 1 in the State List of the Ninth Schedule to the Federal Constitution. Since the SAC has not published its procedure, the plaintiff could not at this instant prove that he had a right to be heard or that he had been derived of his right to be heard. See para 135. Lastly, since there was no limitation imposed on the SEC in the performance of its statutory duty in the Act prior to 25 November 2009, the court should not add or infer any term to suggest any cut-off point to the Act. In any case, the case was registered on 28 January 2010, which was well after the Act came into force, and thus the retrospective issue was of no relevance. That's all from me. Thank you. The next presenter will continue.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Naim and I will continue the presentation. The next presentation is about the case study, which is the Tansi Khalid Ibrahim versus Bank Islam. The background of this case study is there were two legal suits involving the parties. One was a claim by Bank Islam Malaysia Berhad against Tansi Abdul Khalid Ibrahim in suit number D422A2007, and the other was a claim by Tansi Khalid against the bank in suit D422A2162007. Both suits were consolidated pursuant to suit number 22A2272007. This application in Include 5 by Bank Islam Malaysia Berhad was made under Order 14 of the Rules of the High Court 1980s, but a vesting order dated 14 February 2006. All rights and obligations of Bank Islam were transferred to and vested in Bank Islam Malaysia Berhad. Both Bank Islam and Bank Islam Malaysia Berhad will hereafter be referred to interchangeably as the bank. The background fact were that the bank had provided two mubahah facility to Tan Sri Khalid to redeem and acquire more share in a company called Kumpulan Gatri Berhad. However, due to repeated breach by Tan Sri Khalid, the bank offered to restructure the mubahah facility to assist him in his outstanding obligation to the bank. Tan Sri Khalid agreed to the restructure, and by that the two mubahah facility were restructured into a revolving al-Baik Bistaman Ajal facility. Tan Sri Khalid default the first installment under the restructured BB facility agreement, and hence this suit. In Enclosed 5, the bank was employing to enter summary judgment for a sum of $18,521,806 and 113, or its equivalent in ringgit Malaysia. Tan Sri Khalid, however, alleged an existence of a collateral agreement and attempt to challenge the validity of the BB facility agreement on various grounds. The issue that arose were whether there existed a collateral agreement between the parties orally and by conduct, whether the validity of the BBA. Facility agreement was challenged for want of compliance with the principle of Sharia, whether the mode of execution of asset purchase agreement and asset sale agreement was improper because Tan Sri Khalid was made to sign the agreement first before they were passed back to be completed by the bank, whether there was wrongful sale of pledged share because number one, the bank is failure to obtain the consent from Tan Sri Khalid, and second, that there may have been impropriety on the part of CIMB Investment Bank Berhad, who handled the sale of the pledged gratuity share. Next, they had the allowing the application in Enclosed 5. The allegation of an existence of a collateral agreement by Tan Sri Khalid also seemed implausible in view of the two letters by Tan Sri Khalid seeking indulgence from the bank for deferment of payment. The evidence of negotiation, if any, prior to restructuring of the BBA facility agreement was not evident that could be admitted in view of Section 91 and 92 of the Evidence Act 1950, as they directly contradict the express writing provision of the BBA facility agreement. The judgment by Rohana Yusof J. There are two legal suits involving the party. One is a claim by Bank Islam Malaysia Berhad against Tan Sri Abdul Khalid bin Ibrahim in suit number D422A2272007, and the other is a claim by Tan Sri Khalid against the bank in suit D422A2162007. Both suits are now consolidated pursuant to suit number 22A2272007. This application in Enclosed 5 by Bank Islam Malaysia Berhad is made under Order 14 of the Rules of the High Court 1980. The original parties to the agreement are Tan Sri Khalid and Bank Islam Malaysia Berhad. By a vesting order dated 14 February 2006, all rights and obligations of Bank Islam were transferred to and vested in Bank Islam Malaysia. Both Bank Islam Malaysia Berhad will hereafter to interchangeably as the bank. Next, restructuring. Due to repeated breach by Tan Sri Khalid, the bank offered to restructure the mubahah facility to assist him in meeting his outstanding obligation to the bank. Tan Sri Khalid agreed to restructuring when he accepted the offer of the bank dated 17 April 2001 in MR6. By that accepted, the two mubahah facility were restructured into a revolving al-Baik Bitaman Ajal facility. The BBA facility agreement comprised the following documents. Next, the collateral argument. Land counsel for Tansi Khalid, Encik Malik Imtiaz Sawa, Encik Matthew Philip with him, contend that there exists a collateral argument between the parties orally and by conduct. He contends that it was intention of the party to avail Tansi Khalid to take up 20% share in Guthrie within 10 years following an option given to him by Perbadanan Nasional Berhad that the tenure of the BBA facility agreement will it be for a period of 10 years and the principal amount will only be due for payment by 2011. The half-yearly profits due to the bank and the BBA facility agreement will be certified to the transfer of share by Tansi Khalid to the bank and by an allocation of dividend from transfer share to the bank to allow the facility to be seen as performing no payment needed to be made by Tansi Khalid, and the BBA facility agreement will be rolled over at the end of every 6 months as a matter of the course. The illegality. Tansi Khalid challenged the validity of BBA facility agreements for one of compliance with the principle of Sharia. Encik Malik Imtiaz for Tansi Khalid contends that the BBA facility agreement is contrary to principle of Islam due to the following three main reasons. First, the BBA facility agreement either read together with security documents or even independently will denote that there are financing arrangements and not sale transaction as they purport to be. The wrongful sale of pledged shares. Two main issues were raised on the pledged share. First, the bank was alleged to have wrongfully sold the pledged share for failure to obtain the consent from Tansi Khalid. This, according to Encik Malik Imtiaz, is against the principle of Al-Rahnu under the Fund Administration and Custodian Agreement. The background facts. The relationship between the parties began when the bank provided two muabaha facilities to Tansi Khalid. To redeem and acquire more shares in a company called Kumpulan Guthrie Berhad, Tansi Khalid failed to pay the first installment under the first Muabaha Facility Agreement, which was due on 24 October 1998. He sought a deferment of payment of the outstanding VAT, a letter dated 16 October 1998. He also defaulted under the second Muabaha Agreement when he failed to pay the first installment thereunder and sought a deferment of payment with it, a letter dated 20 October 1999. The admission. Having considered all this argument, one fact remained clear. Tansi Khalid had a number of occasions admit his liability to repay the amount due under both Muabaha Agreement and the BBA Facilities Agreement. As I have referred to earlier, his letter in MR3 and MR5 seek to defer payment under the Muabaha Agreements. The Memorandum of Acceptance in MR6 signed by Tansi Khalid admit him owing the bank under the yearly Muabaha Agreements. Exhibit MR6 provide so plainly and clearly that the purpose of the exchange agreement was to finance the existing Muabaha facilities of $50 million and $11,750,000 respectively. Finally, his letter, Exhibit MR31, goes to show his admission on his liability. I agree with Encik Tony Thomas that on this ground alone, this application in enclosed 5 should be granted. The conclusion. The amendment of the CBA in 2003 has given recognition to BMM SAC as the highest reference point for all IFI. The above formulation also acknowledged the authority of the arbitrator as one of the process in dispute resolution in cases involving Islamic banking matters. The advice made by the SAC will be equally binding on the decision of the arbitration tribunal. The decision of the SAC should be equally binding on the judge of the civil court to the end of dispute on the substantive interpretation of Sharia principle. Otherwise, the problem of substantive interpretation of Islamic banking practice might to harm Islamic banking development in the future, particularly in legal dispute at the civil court. Recent court decisions have proven that in resolving dispute arising from Islamic finance contract, Sharia rule and principle do not necessarily apply. In actual fact and based on evidence produced, the issue in dispute are not Sharia in nature, but rather specific to the civil and commercial rights and obligations as contracted by the parties. Contention on the illegality of the transaction in the eyes of the Sharia often appears to be an afterthought to avoid payment of the debt, or as initially it was not an issue for the parties at the contracting stage. Genuine contest over Sharia compliance is very rarely proven. Dispute often highlight the form of substance issue. Form versus substance is not a new issue in Sharia and Muamalat. It has been raised long before and will continue to be raised. Realistically, we may never have definitive answer. From experience, form over substance is not much of a question of law, but rather a question of fact. That is why each time the issue has contested in law, the court will need to find the best on evidence.